At the Wisconsin Supreme Court this morning, justices heard arguments in a precursor case to a highly anticipated decision on the Union Law Act 10. Political reporter Will Keneally is at the Capitol and has more.
This case revolves around UW nurses and whether they should be included in that Act 10 law that stripped collective bargaining rights from many public sector employees. Now, attorneys defending the law called it a bait and switch.
There is an element of all of this that I must confess feels a little bit like the emperor's new clothes.
A unique analogy for a complex case in state law.
Everyone has a firm grasp on reality until a new tailor comes to town and says, I'm going to make you a garment that only the most sophisticated people can see.
Wednesday's union case with UW nurses challenges an application of how Act 10 is applied. The 2011 law eliminated union rights for many public sector employees like UW nurses.
And now we're presented with this interpretation of what happened in Act 10 that everyone knows is not what happened. And we're asked to accept that as reality. Well, you know what happened to the emperor in the emperor's new clothes.
The union argues that how the hospital is organized, it functions more like a private entity. Now, where the emperor's clothes come in here is that would change the interpretation of Act 10, making those nurses a private sector union instead of a public sector union.
This organization operates just like St. Mary's, just like Meritor. It is a multi-state entity with clinics and hospitals and employees in Illinois. The whole point of creating the authority was to make them able to compete with private entities.
The court has a liberal majority, and we could see them side for the union. This is one of the major union cases that we will see before the court rules on Act 10 in its entirety. Now, the court is expected to hear that full Act 10 case later this year. Reporting from the state capitol, Will Keneally, News 3 Now.